It's the second week of the legislative session. People are exhausted already. Why is that? Some things out front, some things behind the scenes. You're going to learn about that here right now. It's Mitchell Talks the News 9 Sessions with Aaron Burlbeck and the president of the DAs, Brian Hermans. Thanks for joining, everyone. Good to see you. Good to see Mr. Burlbeck. Mr. District Attorney, how are you? Good to see you, sir.
Very good, thank you.
You know, this is something we've talked about a little bit before. When it comes to reporting, there's the thing that's on the record, right?
Right.
The stuff that's out front, but sometimes it's behind the scenes. As you well know, the stuff that's happening is behind the scenes, and that's not what the public gets into a lot.
Right.
There's a lot you can't report, right? But there's a bunch of stuff going on. We're talking criminal justice reform, Mr. District Attorney. Why don't you take it away? What are you hearing about?
Well,
this?
that's the buzzword of this legislative session is criminal justice reform. Last year, if it was anything, it was education. This year, education is still big, but we're hearing mostly about criminal justice reform and ways to properly reduce our prison population without putting the public in danger. And that's where that fine line is. And we're getting a lot of information, we're getting a lot of misinformation, and that's what brings you here.
It's good to see you, sir.
Good to see you.
Tell us, and by the way, I mean, I'm hearing this, you're hearing this. In fact, we'll be nice about this, but there are some people out there saying some advocates are not exactly telling the truth. So let's set the record straight, because you guys catch heat all the time, right? As prosecutors, and the DAs are doing this, the DAs are doing that. Let's start with misinformation, your words. What are the things that are being said that the DAs, the District Attorney's Council represents all the DAs across Oklahoma, that just simply aren't true in your opinion?
Well, one of the things I'm hearing a lot right now is that the district attorneys are filing more possessions with intent to distribute in drug cases because of 780. And that couldn't be further from the truth. We have certain criteria we look at in determining whether or not that exists. If it's there, we will file those charges. We have not done anything in a reaction to the passing of 780. But times have changed. There are now a lot more drugs on the street than there were before because possession of drugs is a misdemeanor. And therefore, more people are selling drugs to persons that are at the end users, and therefore there are more charges probably being filed in that area because of the unintended consequences of 780.
Is 780, 781, is it working?
Well, I don't think 781 is working at all. 781 was supposedly a collection of the money saved by people not going to prison, and I have not heard of any money being deposited in that account. As far as 780, is it cutting down the number of felonies being filed? Yes, it is, because those charges are no longer felonies. But is it stopping people from using drugs? No. Is it getting sold that let's get mental health to people, let's get them treatment for this? Well, I think they're getting less treatment because of 780. When we prosecuted a case of methamphetamine, let's say, one of the requirements we would have for those persons is they would get mental health care. They would go do an evaluation. It's called an alcohol or drug evaluation. That evaluation would determine what they needed for a treatment plan, and they'd be required to complete that treatment plan as a part of their sentence. They would seldom go to prison for a first, second, even third offense of possession of methamphetamine. Now, many of these charges, both either marijuana and sometimes harsher drugs, are going to municipal courts, and municipal courts are finding these people and aren't requiring any type of mental health component. Therefore, there's no therapeutic help for these users. They're just using, being fined, going out and using again and being fined. So how it was sold to the public, let's get them some mental health, is not what's happening. They're actually getting less help, and they're just using.
So was 781 just poorly written then, or should it have been more specific in terms of, how do we fix this, I guess is the question.
When 781 was going on, we told people that there weren't that many people in prison on possession offenses. Most people that are in prison with possession offenses had other things that were putting them in jail. They were in drug court, and they violated drug court and therefore were put in prison. Or they had other requirements and had new crimes and such, and were going to prison. That number was very finite, and there wasn't going to be a huge saving by 780 being passed. I think that's come true to fruition, that when there's not a lot of saving, it's not a matter of badly written, it just wasn't well thought out, I believe.
One of the things we hear a lot is that the prisons are full of people for simple possession. True or false?
False. When that bill was being pushed around, we were hearing of the tens of thousands of people in prison that were put in there for possession charges. Later on, when that group that was pushing that moved to another area, they're saying, oh, there's not that many people in there, the prisons are still overcrowded, we've got to do this, 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 and this. And if you listen to what they said at first and what they're saying at the end, it doesn't make sense. And the truth of the matter is, there are probably less than 1,000 people in prison on possession charges. Many of those people are people that failed drug court, people that have new crimes, people that weren't put in there because of the initial crime that they had done for the possession charge.
The controlling offense.
The controlling offense, yes.
Can you tell us how that, by the way, I hate to interrupt, but
No.
tell us how this works, because people say, well, they'll look at this and they'll say he's in prison for a drug possession. But does that tell what alls he could have been charged with, what they pled to, or he or she? That's confusing, I think, to a lot of people.
It's very confusing, such as there's an offense called trafficking, which means a lot of weight was found with this person. And then, of course, possession with intent to distribute, which means there were indicators or proof that they were selling the drugs. Sometimes those cases, those charges are dropped down to possession as a plea deal and gets them into prison because of the type of crime they committed, but it was pled down to a lower offense. So when you see possession, you may not understand really what this person really did and why they went to prison in the first place.
Is that something that has permeated the media and the public? I mean, in terms of messaging, when you're talking about this, there are many folks out there that are messaging, and let's face it, you guys' messaging is not that great. No. I mean, agree?
I agree.
So the point is, and kind of the onus is that you've got to start pushing back on some of these issues. Are you ready to be aggressive to do it?
Well, we're not the best at that type of politics. We are people that every day what we do is we try to protect public safety. We're in the courtroom, we're trying cases. We're going up to the legislature, going to the news media and explaining our case very well, because we've got a caseload. You know, a typical prosecutor has about 500 cases they're handling every year. That keeps us in the courtroom. So we don't have that time, but we hope that people see what we're doing and understand what we're saying.
There's a bill that's working its way through the legislature right now that would change the way that fines and fees are collected. The theory behind it is that a lot of district attorneys right now, they make half of their budget from these fees and fines. So they'll sometimes prosecute or overly prosecute to get that paycheck, and when folks can't make those payments, when they can't make that money, what they do is they wind up finding themselves locked up. So the theory behind it is we would change the way that money would be collected, those fees and fines, so that there's no more incentive for district attorneys to force these prosecutions they may not necessarily be needing to force, and then the money would instead go to the state would redistribute it from office to office. What's your take on that?
I'd like to break that down into two different areas. First of all, the fallacy that we're charging people because we need the money. We don't do that. That is the least of our reasons. We're not a debtor's prison operation. We file charges against people because they committed a crime. The legislature, in their infinite wisdom, said the way you pay for your office is by charging people for supervision, charging people for reimbursement of the cost of the prosecution, and pay for the court system by the fines and the costs. The fines and costs go to the courts. And really, those are the people that can least afford to pay because they're the defendants. There's some logic that making the person that commits the crime pay for it. There's some logic there, but we're putting these people in a hole. Prosecutors all along have said, don't do that. Pay for us like every other state agency. Fully fund us and find other ways. But to fund us and then still take this money from these defendants doesn't make sense either, because they're still going to be in the same hole, trying to find work and not still owing all the money to the court systems and to the district attorney's offices. Some of the fallacy, they're saying on one hand, the DAs are putting everyone in jail because they want to fund their budget. But if we put someone in jail, they're not paying fines, they're not paying costs. So that's the fallacy of that whole argument. We are trying to protect the public, and by that, making sure those persons that deserve to be in jail go to jail, and those that need to be on programs of some type of parole or some type of release, make sure they follow those programs. We have a special docket in my courts where if a person fails to make their payments, we don't file charges against them. We bring them in before the judge, and the judge sets up a payment plan, an adjusted payment plan, and if they violate that, they go to jail for 30 days. They don't go to prison. And then they say, okay, now you need to pay it. We try to find ways to encourage them to follow the rules and conditions placed upon them.
So based on that, crystal ball it for me. Should this pass, would you expect to see any change whatsoever in the rate of conviction?
No, it won't affect convictions at all. We're not driven by the money of those situations. We're driven by public safety. again, we're in favor of fully funding the district attorneys. We're in favor of dropping the cost to the defendants, but I don't see that bill accomplishing the end result that they want.
Are you all opposed to that bill?
We're not going to take a position against it, even though we'd love to see it fine-tuned to better accommodate the situation we're faced with.
How would you fine-tune it?
I would look at how much we want to place on the burdens of the defendants financially for when they get out of prison or when they get out of jail or when they just finish their plea. Look at ways of not paying for the judges by that system, not by paying for the DAs by that system. Look for ways of making sure they are accountable by doing mental health stuff. Spend that money on programs. Spend that money on a GED. Spend that money on the ways that they're going to improve themselves and not come back to the system.
Let me ask you about what's going on behind. Now we're into the behind-the-scenes stuff, domestic violence.
Yes.
There has been for 2 or 3 years now. Remember, 3 years ago, there was some legislation did move in the House. The lawmakers took a bucket load of heat over that sort of stuff, and then people came back to me. Sources said, "Look, that was about reducing the penalties on strangulation." And there's been a lot of discussions about this behind the scenes that I don't see out on the surface. Let's start with this. What is happening with the discussion? We know Joe Dorman's group, Oklahoma Institute for Child Advocacy, has been against some of the legislation out there, saying you're going to, not you, but the legislation would reduce penalties for failure to protect, which is a controversial issue, and then strangulation, that there have been some folks out there trying to pull back on that, which is my understanding is if a abuser at any point strangles somebody, that's an indication of lethality, that down the road they're going to kill that person. But what's going on DV? Just help us set that straight. I don't think there's anything out there that is more murky, and I hear more from both sides. It's just radically different, the talking points.
Yeah, part of what Scott's talking about there is we've got several women who are in prison right now facing more serious charges because they didn't report a child abuser than the child abuser himself.
That's a very complicated issue, and let's talk about that first. That does happen occasionally. Not in a perfect system, you'd say, why would that occur? But there's an example of a case, I believe, out of Enid, where the woman and the man were given the same opportunity to the same sentence, and their child had died, and it was terrible pictures, terrible situation that they neglected that child and failed to protect. He took the deal. She pled guilty, but decided not to take the deal and pled blind. And in a blind plea to the judge, she received 10 more years than the husband did.
Can we interrupt you for just a second? Explain what we just heard. He took the deal, she didn't. Why would that be?
Okay. She felt that she perhaps in an argument to the judge could get a lesser sentence than what he got. And so she argued based on the fact situation that she felt it would be less. The facts were terrible. The house smelled like urine, there were feces all over the place. The child's injuries physically were terrible. And the court, and I wasn't in the courtroom when that happened, but obviously the court heard that evidence and felt the punishment needed to be greater than what the offer was made to the husband. Those things happen when you take that risk. She took a calculated risk, and because of that, she lost. And so that situation, in a perfect world, they should be close to the same. But with the legislation that limits that, causes some problems. Let's say the husband and wife are still together. And let's say it comes time for his sentencing or his trial, and she gets up and says, he didn't do anything, he wasn't at fault, you shouldn't be able to do that to him, and he gets a low sentence. Now, or found not guilty. Should she get a not guilty verdict because she covered for him at a trial and testified to that? No, she should be held accountable for the acts that she did. So for us to tie our hands, that would be wrong. DAs usually try to be fair. And by trying to be fair, we're going to try to come up with a result that would be fair to all parties. But in a situation where they tie our hands and say you can't get more than what the other person gets, causes a great deal of difficulty. Sometimes the only person that confessed was the wife. But again, don't think the numbers are outrageous. There aren't that many people in prison for failure to protect, not many women in prison for failure to protect. It's a relatively low number. And why would we not want to protect the children from persons that are failing to protect them? On domestic violence, what's shocking about domestic violence is that strangulation that you talked about, that domestic violence by strangulation is a non-violent offense. I can't think of anything more violent than trying to strangle someone to death, but that's a non-violent offense. So when they're talking about these non-violent offenses, they're talking about things like that. Great bodily harm in domestic violence is a nonviolent offense. That is shocking. That needs to be changed. And some of the legislation that I'm seeing right now will put limits upon the second offense would only be 25% more than the first offense. So the second time you try to strangle this person to death, you're only going to get another couple of years to your offense. And the third time it's still going to be the same thing. So you may end up with a possible 12 years on your third and fourth offense for domestic violence by strangulation. That's wrong. You need to give the prosecutors the range where they can punish the person appropriately for what they're doing out there.
Domestic violence advocates might argue, though, that oftentimes within domestic violence situations, it's not just a question of physical abuse, it's also years and years of psychological manipulation. So should a woman face those same types of penalties if she's just been beaten down after years and years and years of psychological abuse to the point where she's so afraid she can't call the police?
Remember, these are just ranges. And if that occurs, and that evidence is presented to the prosecutor, presented to the jury, that's going to be listened to. And I know one of the bills out there right now says that the court will hear that type of evidence as to whether or not that person suffered those things and was fearful of retribution for what her actions or his actions may have been. And the courts, I think, do that already, but certainly there's nothing wrong with the court being fully aware of all the circumstances that go around the events that happen whenever the incident occurred. I think the court knowing those things is a smart thing.
In your opinion, this legislation you're talking about, I guess there's several bills out there, would it make it more dangerous to be a victim of domestic violence and children in the house where domestic violence is ongoing?
These new bills will make it easier for the person not to suffer, the person that's doing the domestic violence to suffer great criminal punishment.
You're saying it helps the perps.
It does. It does. And that's the bottom line. So domestic violence is one of the hardest things for our offices to prosecute. Many times the person gets bonded out of jail by the victim. The victim does not want to cooperate. It's a difficult case. And when we can get them proved, they're usually the worst of cases. And to say that we're limited on what the range of punishment is to 10 years on a serious violent offense like that doesn't look at the worst cases that we have to deal with.
Let's assume goodwill on all parties.
Absolutely.
If you're, that instance you just spoke about, so the people that are advocating these positions, are they just not educated enough to understand how the system works, or they have another agenda?
Well, I don't know who all the people are, because certainly, so I'd hate to say all the people are this way, but
We're not sure, right?
Yeah.
I mean, it's very murky.
Many of those people aren't in the courtrooms. Many of the people are not sitting in our victim witness areas talking to the woman with the black eye, the marks on her throat, not looking at the children that have been watching their parents being abused. We just got a prisoner back just this week who stabbed his wife over 40 times after several domestic abuse situations. Many of these are going to go forward and end up with some type of homicide somewhere down the road. Not all, and probably not a majority, but some. I think the people that are making these arguments, many of them, in fairness to them, some of them are strong advocates for certain positions, but I don't think they talk about the victims. I don't think they talk about stopping additional crime from happening in the future. We want to stop future crime. We want to stop crime before it happens and not give these persons a chance to reoffend.
We're running out of time, so I just want to hit you up on this real quick. We were talking a little bit before we started going on air, and you had said something to me that was kind of surprising, I think, to both Scott and myself, that there are a lot of people that are in prison right now who are in prison because they decided to be in prison because they don't want to take advantage of parole.
Is a shocking thing. It's called the waivers, and what it is that when a person is in prison, after so much time in prison, they have the right to go before the parole board and have their case heard as to whether or not they should be released early. And if they aren't released the first time, they'll come back again and again until they're finally released on parole. More and more people are saying, no, I don't want that hearing. I waive my right to a parole hearing, because they want to serve the full time and get out of prison without having any restriction on what they can do in the future. It's if they come out and they have still paper time, they can be required to go to AA, NA classes. They can be required to do other types of programs. So they stay in. They waive. 400 people a month waive their rights to parole. That's 4,800 people a year, every year. Now, if we do away with that, those people will at least be considered, and some of those people would be released on parole. To do that, we need to give the parole board more money so they can hire more investigators and do the things they need to
I
do.
think the
for those
governor's
educations.
proposed that, correct?
Right. But I know the stats are that back in 2008, there were some 1,200 people released on parole. In 2018, there were 250.
Wow.
There's a crazy drop. I think they need some more funding at the Pardon Parole Board so that they can look at these additional cases, and we need to tell these people, no, when you qualify parole, we're going to give you a hearing and determine if it's time to let you release with time still on paper.
Yeah, they shouldn't have the right to make that decision.
Absolutely.
Well, Mr. Hermanson, thanks very much for coming by. I feel like that we're shed some light on this. It looks to me like the media needs to be doing a better job.
I learned a lot.
Yeah, same here.
Thank you.
Thank you, Mr. Railback. See this again at news9.com/yourvotecounts. Follow me, Scott Mitchell, on Twitter at Mitchell Talks. Thanks for dropping by.